Peace, peace, peace. We're going to start right off with some knowledge. It's 11:10. Within the next 60 minutes, it'll be 11:11 on 11/11/2023. Numbers 11/11/7. And we are getting right into the information, busting up some portals of the mind, right? Let's learn a little bit about this law and equity going into the midnight in this portal opening evening. Let's go.
Sir William Blackstone as to the meaning of the term jus civile, as used in the Roman law. According to the conception of the Roman lawyers, as we have already explained, the law is made up of two elements, viz., the jus gentium and the jus civile, the former consisting of those rational principles which are common to, and indeed constitute the principal part of, all systems of law, and the latter, of the arbitrary or accidental rules peculiar to any given system. According to this view, which is obviously the true one, the jus civile constitutes, not the whole, but only a part of the law, and indeed, if we have regard to importance rather than bulk, we may say a very inconsiderable part of it. But Blackstone unfortunately mistook it for the whole, and avowedly founded his definition upon it. So obvious a blunder could hardly have occurred, and still less, for over a century, have escaped detection, had it not been for the unfortunate ambiguity of the term law, which, in its most familiar sense, denotes a law or statute, /x, or an aggregate of such laws, but which is also used to denote the more complex subject, which we call the law, and which in its latter application has naturally carried with it its more familiar connotation. For, in all other languages but our own, what we call the law is denoted by a term signifying recht, as, for instance, in the Latin by fus, in the German by recht, in the French by droit, in the Italian by diritto, etc., a usage once common with ourselves, and not yet altogether obsolete, as, for example, in the term fo/k right, the ancient name of the common law, and, in its later equivalent, common right. Asterisk, by this usage of terms, and by their familiarity with the conceptions of the Roman jurists, the lawyers of continental Europe have been preserved from this error, and hence the conception of the law involved in the definition is a peculiar growth, or rather excrescence, of English jurisprudence, and, as observed by Sir Henry Maine, is not so much as * known on the continent at all. To Blackstone himself and to the lawyers of his time the definition carried with it but little significance. They knew the law too well to be misled by it, and hence their practical conception of the law, as evidenced by their works, was altogether different from, and inconsistent with, that embodied in their formal definition. But unfortunately the definition fell into the hands of Bentham and Austin, by whom, or rather by the latter of whom, it was developed into a formal and comprehensive theory which has of late years, in England and this country, almost entirely usurped the whole domain of theoretical jurisprudence, and which has exercised, and still continues to exercise, an almost despotic dominion over the English and American mind. This theory rests entirely upon the definition as its foundation, and is in fact but a mere series of deductions from it. Its principal tenets may be briefly stated in the following propositions. Municipal or civil law, he says, that is, the rule by which particular districts, communities, or nations are governed is thus defined by Justinian, jus civile est quid quisque sibi populus constituit. 1 com. 44 It the common law had an ancienter original than Edwin the Confessor, and was first called the /OK right, or the people's right. Aston, J., in Miller v. Taylor, for Burr. 2343, and it is to be observed, the common law of England is sometimes called right, sometimes common right, and sometimes communis justitia.
Common
in
right.
The Great Charter the common law is called right.
Common law.
Nulli vendimus, nul negabimus, aut differimus justitium vel rectum. Colit. $142 Bill Commander 66. 1 The law is a mere expression of the will of the supreme government.
The will of the government. Who's the government?
The courts in fact exercise legislative
of your
functions.
State, of mine.
Hence judicial decisions are mere expressions of the will of the state through its officers, the judges, and in their essential nature differ in no respect from statutes or legislative acts. 3. Custom is no part of the law until recognized and adopted by the government, either through its legislature or the courts. 4. International law is not law in the true sense. 5. Nor is constitutional law. 6. Rights are mere creatures of the will of the supreme government. 7. Hence there are no such things as natural rights. 8. Hence the state itself cannot have any rights, or be subject to any obligations, either as to its own citizens or as to foreign nations. 9. The legislative will
Damn,
is not
15 of
only the
y'all in here
source
ain't
of rights,
nobody said hi.
but the
Y'all so
paramount
damn
standard
rude
of the
and
just and
ignorant.
the unjust,
Like
and
for
of
real.
right and wrong generally.
Each and every one of y'all.
L10. The power of the sovereign is incapable of
Each and
legal
every
limitation.
one. Yeah, drop
Or,
y'all ass
in
off.
other words, the supreme government is legally
weirdos.
absolute, or despotic. With a little reflection it will be perceived that all the above conclusions follow logically from the definition, and cannot be consistently rejected by anyone who accepts it. It is obvious,
Rudest
therefore,
damn people,
that the
I swear.
definition, as well as the theory based upon it, is subversive of human rights and liberty, and of morality itself, and the mere statement of the
Nosy
theory may
asses,
be,
lazy.
therefore, taken as a reductio ad absurdum of the definition. We have dwelt at length upon this definition, because it is almost universally received by the profession, and because, as we have already remarked, so long as this continues to be the case no intelligent study of the law, in its scientific aspect, is possible. The second definition defines the law as consisting of the general customs of the realm, or state. This definition is of earlier date than the former, and is supported by the concurrent authority of all our writers, ancient and modern. The essential idea intended to be conveyed by it is beyond all question correct, for there is no fact more certain or more important than that all law rests in the main upon custom. But, as expressed, the definition is inaccurate, for it is obvious that custom is only one of the elements of the law. The third definition regards the law as identical with justice. This is implied in our common speech, as, for example, when we speak of courts of justice, or of the administration of justice, and is expressly asserted by the highest authorities. Thus Blackstone, following the Roman lawyers, defines jurisprudence, or the knowledge of the law, as the science of the just and the unjust, justiat conjusti scientia, and the law as the art of the good and the equitable, ars boni et equi, and accordingly he says, justice, therefore, is the virtue, jurisprudence the science, justice the end, summum bonum, jurisprudence the means. And with this agrees precisely the definition of Sir Matthew Hale, according to which the common law of. This is shown more at length in an article published in the American Law Review, March-April 1887, entitled The English Analytical Jurists, where will be found condensed into a brief space a clear view of the theory of jurisprudence generally accepted in England and this country. 1 Blackstone, com. 63. England is i.e. common rule for administering justice within this kingdom, and also the forms of the old commissions to the judges, which were, facturi quod ad justitiam pertinet secundum legem et consuetudinem Anglia, and indeed the books are full of expressions of eminent jurists which, in effect, assert the same proposition. But, to say the least, this definition is inaccurate, for the law is obviously made up in part of laws and customs, the former of which are purely arbitrary, and the latter to a large extent accidental, and both often unreasonable and absurd. The common fault of all these definitions is that they each regard only a part of the law, and ignore the remainder.
A part of the
For
law.
the law is in fact made up of laws or statutes, customs, and principles of natural reason, and no definition which ignores either of these elements, or which fails to express the manner in which they are related to the law and to each other, can be accepted as satisfactory. The fourth definition, or supposed definition, does not aim to express the essential nature of the law, but merely to distinguish and identify and thus to determine the proper subject of our investigation. According to it, the law is simply the aggregate of the principles and rules, whether arbitrary, accidental, or of natural reason, by which the courts are governed in the exercise of jurisdiction, or, as expressed by Sir Matthew Hale, it is generally that law by which the determinations in the King's ordinary courts are guided. This definition, or rather description, of the law is equally consistent with all the definitions given, and indeed with any definition that can be devised. Hence it furnishes a common ground upon which the advocates of all theories of jurisprudence may stand at least equally well, and it may be conveniently used as giving a rough and approximately correct description of the law. Let it be assumed, therefore, for the purpose of defining the scope of our inquiries, that the law, whose nature we are seeking to ascertain is the law which the courts enforce, or at least are supposed to enforce, or, more specifically, that it is the aggregate of the rules and principles by which the courts are governed in the exercise of jurisdiction. This description of the law, however, gives us no information as to the essential nature of the rules of conduct which are thus enforced, and which, according to it, constitute the law. It remains, therefore, to investigate the nature of these rules or principles, a problem purely historical, and which can only be solved by an examination of some actually existing system of law. In making this investigation we will, for obvious reasons, generally have in view our own, or the American, law, but what we will have to say will be equally applicable to all systems. 8.3. Division of the law. The law is not a homogeneous whole, but consists of several different. Lit. 142a3, see especially county. Lit. 142a, 158b, 976, 97b. This is also in effect the definition of Bonnie Herring, who defines the law as embracing all the principles of law, enforced by the state. Struggle for law, 5, and that of Bliss, who defines it as the aggregate of the rules recognized or prescribed by the supreme power of the state regulating the property and personal relations of men, SOV, 52, and that of Holland, Jur. 12, according to which a law is a general rule of external conduct enforced by a sovereign power, and the law merely an aggregate of laws. In fact, however, these and the definition in P are not definitions in the true sense, but mere statements of the subject to parts or branches, which differ essentially in their nature. Its nature, therefore, can only be understood by an analysis and separation of it into its several parts, and by the division and subdivision of each part, until we have presented to our view, as a connected whole, the various subjects which make up the aggregate which we call the law. Our first step, therefore, will be to examine and analyze the law as it is actually administered by the courts. If we observe the course of business in the courts of ordinary civil and criminal jurisdiction, we shall find that they are exclusively occupied either in determining controversies between individuals with reference to their reciprocal claims and demands upon each other, or in determining accusations of crime, which, in effect, are controversies between individuals and the state. The power to hear and determine such controversies is called jurisdiction, and is either civil or criminal, the former consisting in jurisdiction over civil cases, or controversies between individuals, and the latter in jurisdiction over criminal cases, or accusations of crime. An obvious division of the law, therefore, is into the civil and the criminal law, the former being the branch of the law which governs the exercise of civil, and the latter that which governs the exercise of criminal jurisdiction. The criminal law in this country consists almost wholly of statutory enactments, which are simple in their nature and readily understood, and a sufficient knowledge of it for purposes of the general practitioner can, therefore, be readily acquired by the student by the perusal of the criminal code of his particular state, and perhaps, also, of some good textbook on the subject. It differs so essentially from the civil law in its nature that it will only produce confusion to consider them together, and we will, therefore, for the present, dismiss it from consideration, adding only that the civil law is the branch of the law with which lawyers in general are principally and indeed almost exclusively, concerned. The civil law is that branch of the law by which the determination of civil cases is provided for and governed, and it consists of the law of civil procedure and the law of private right, jus
Civil
privatum.
procedure and private
The
right,
former will
equity.
first be briefly explained. To every civil controversy there are two parties, viz. the plaintiff and the defendant, actor and res. The former is he who demands relief from the court against another, the latter, he against whom the relief is demanded. The proceeding by which the demand is made by the plaintiff and resisted by the defendant is called a suit, fors, and also an action, actio. The latter term, however, has a more appropriate signification, in which we shall be compelled habitually to use it, and we will, therefore, in the present connection, use the former exclusively. In general, the determination of a suit involves two classes of questions, which are distinguished as questions of law and questions of fact. The latter depend for their determination upon the evidence, the former, upon general rules and principles, which in the aggregate constitute the law. Jurisdiction is the power to hear and determine the subject in controversy between parties to a suit. Rhode Island v. Massachusetts, 12 Pet. 717. It has also been defined as an authority or power which a man hath to do justice in causes of complaint brought before him. Jacobs's Law Dictionary, Jurisdiction. Questions of law are again of two kinds, viz., those which relate to jurisdiction, or other points of procedure, and those which relate to the merits of the controversy, or, as they are called, questions of right. The determination of questions of fact is part of the procedure in a case, and the subject of evidence, therefore, belongs to the law of civil procedure, the whole object of which is to elicit and present to a competent tribunal the question of right involved in the case. The law of civil procedure may, therefore, be described as that branch of the law which provides for the creation of a jurisdiction, and which regulates the mode of procedure to be followed by the parties and the court in the conduct of the case, including the determination of all questions of fact, in order to elicit the questions of right involved, and which also regulates the subsequent proceedings necessary to carry the judgment of the court into effect.
Let's get into Chancery Court, where you will put these things into effect, putting equity into your suit. Listen up. I'm gonna go down. We're gonna read this. Suits in Chancery Court, setting forth the principles, the pleadings, the practice, and the proofs and processes of the jurisprudence of equity, giving numerous illustrations and forms. So we'll go through a few. We're not going to go through all of them. It's over 1,200 pages here, but we're going to go through a few just so you guys get an understanding of what equity is. I'm actually going to go through the introduction so you can really understand what a little bit about the familiarity of family and private, being a part of that, so on and so forth. So let's start here.
While there is a general family resemblance between the systems of jurisprudence prevalent in the various states of the Union, the differences and peculiarities in their systems of pleading and practice are, nevertheless, so great that no work, dealing with the procedure in courts, is of much practical value to the practitioner, unless it is adapted to the jurisprudence and practice of the particular state in which he lives. Books of general practice, with footnotes of the diverse rulings in various states, are often more confusing than enlightening. What the practitioner needs is a book on court procedure that omits everything that is not the law in his own state, and contains everything that he is likely to need in the progress of a suit. Such a book I have endeavored to make this, so far as the Chancery practice is concerned. What ordinarily happens in a litigation can well be compressed into one volume, but what very seldom happens, the unusual and the possible, would fill several volumes. What happens in matters of pleading and practice in 99 out of every 100 suits, I have labored to give. What may happen in the 100th suit, I have not striven to forecast. The ordinary law is comparatively small in compass. It is the exceptional and the uncommon that necessitate a multiplicity of books, and fill libraries. And while I have not attempted to give what is exceptional and uncommon, My purpose has been to give everything likely to prove of value, to be found in our statutes, decisions, and rules of practice, and in standard authorities on the subject. 1. In matters of equity jurisprudence, this work is based mainly on Pomeroy, Story, and the statutes and judicial decisions of our own state. 2. In matters of chancery pleading, I have followed Story, insofar as consistent with our statutes. Daniel and Barber have, also, been drawn on, quite largely. The many differences, between our system of pleading and that of the English Court of Chancery, are clearly pointed out, where necessary to prevent confusion. 3. In matters of chancery practice, the works of Daniel and Barber have been relied
If
on
you are
when consistent with
practicing
our statutes,
in your
decisions,
if you are
rules.
in your correct status, right, you're able to go for equity in Chancery Court. There are 5 Chancery courts in the United States, 5 federal, over the federal, because they are Chancery, but there are 5 top courts, the only true courts in the land. All other courts are administrative procedure, dealing in commerce, right, trading you on the stock market.
The practice and system of jurisprudence. Vio preface. 4. In drawing the forms, pleadings, orders, and decrees, brevity, simplicity, perspicuity, and precision have been constantly kept in view, and surplusage and prolixity have been avoided and reprehended. 5. In the arrangement of the contents of the book, everything has been given in the order of time in which it usually takes place in the progress of a suit, when possible so to do. 6. In providing means for finding any particular matter in the book, a full index has been given in the back part of the book, and a complete table of contents in the front part of the book, and the titles of the chapters and articles have been given in the top margins of the book, and many crossed references will be found in the footnotes. Each section begins with a statement of its subject, in bold-faced type. The object of this work is to aid those who minister in the chancery courts, and to contribute somewhat to the improvement of the pleadings and practice in those courts. Henry R. Gibson. Whatever a man does he flatters himself he can improve on, and so the author of the first edition of this work, better aware of its deficiencies than anyone else, began the preparation of what he hoped would be an improved edition before the first had been fully printed. The main object of the original edition was expressed in its title and preface, but it left many suits in chancery unconsidered, and left others very imperfectly considered. To supply these deficiencies is the main object of the present edition. The deficiencies in the first edition were caused, first, by an apprehension that the necessary additional matter would make too unwieldy a volume, and second, by the author's duties as chancellor engrossing too much of his time. In preparing this edition, the author has had adequate time, and the suggestions of a considerable proportion of the lawyers of the state, besides the use of the Law Library of Congress for over 10 years, so he hopes the deficiencies have been reduced to the minimum consistent with 1 volume. The present edition, which contains 20% or more matter than the original, treats of every kind of suit in chancery the average lawyer will be called on to bring, or defend, in an average lifetime. The suits oftenest brought being most fully considered. The author cannot forbear expressing his gratitude to the judges and chancellors of the state, and to the members of the bar, for their kind reception of the first edition. It largely compensated him for the drudgery devoted to its compilation and publication. In this connection it may not be out of place to say, that none of the references to reports and textbooks in either edition are second-hand, but are the results of original investigation, and can be implicitly relied on. The code references are, unless otherwise noted, to the Code of 1858. The reasons for this are, first, it is the only statutory code of the state. 2d. All subsequent codes contain it, so far as extant, and third, this work may outlive the temporary codes of individuals, of which there have already been 4, but cannot hope to outlive the code of the state. Statutes passed since the Code of 1858 are usually referred to by the date and chapter of the Act. The quotations of maxims to illustrate the text will, it is believed, prove helpful. No book that treats of equity is complete without them. They are not the mere gewgaws of pedantic lore, but the crystallized wisdom of the law, polished and preserved by the masters of
Crystal
jurisprudence.
wisdom of the law.
Henry R. Gibson. Knoxville, Tennessee, March 4, 1907. 161 AJL sections have been omitted or consolidated, 2 ad equifrequentius accent of jura adaptantur, and 244 new sections added. Over 1,000 of the old sections have been rewritten, or revised.
Rewritten and revised.
The Chancery Court, its history, jurisdiction, and principles. Chapter I. The history of the Chancery Court. Sections. Article I. The origin and evolution of equity jurisprudence. 1 to 9 IL. The history of the Chancery Courts of Tennessee. 10 to 15. Chapter IL. Jurisdiction of the Chancery Court. Article IL. Jurisdiction of the Chancery Courts generally considered. 16 to 22 IL. Equitable, or inherent, jurisdiction of the Chancery Court. 23 to 25 HL. Statutory jurisdiction of the Chancery Court. 26 to 30. Chapter 3. Maxims and principles of equity. Article I. Maxims and principles of jurisdiction. 0000. 31 to 40 IL. Maxims and principles of adjudication. 000. 41 to 63. Maxims applicable to the court, and to its practice and pleading. 61 to 64. Chapter 4. Notice, lis pendens, estoppel, acquiescence, negligence, laches, waiver, and consent. Article I. Notice, lis pendens, estoppel, acquiescence, negligence, and laches. PLLDR Atenina Nizaoaea Erade more 65 to 70 TK. Waiver and consent EY SUS APA DRIA EET 71 to 72 priorities, and bona fide purchasers. 73 to 76. Proceedings in a suit in Chancery, from its preliminaries to the appearance of the defendant. Chapter 6. Sections. Proceedings preliminary to a suit. 77 to 79. Chapter Bill. Parties to suits in Chancery. Article L. Who may sue in Chancery. 00CCCCCC 80 to 85 IL. Who may be sued in Chancery. CC. 86 to 89. 3. General rules as to parties. CC 90 to 95. 4. Who should be complainants. CC 96 to 99. V. Who should be defendants. Econa MV Lana Ta 100 to 102. 6. Next, friends and guardians ad litem. Is 103 to 108. Bill misjoinder and non-joinder of parties. EEE 109 to 112. VIIL effect of death or marriage of parties, or assignment of their interests. Org site 8 or TE site NE2 UN Al 113 to 116. 9. Parties in particular suits. 0. 0 CCECCCCEEEC net EEEAs 117 to 127. X parties in suits by and against the state, counties, cities, and corporations. SARDASEO or quad eddy dates EACAE Hare CE 128 to 131. Chapter 8. Original bills in Chancery. Arict I. Original bills generally considered. 0 CECC in case 132 to 138 IL. Frame of an original bill ZXRRGAE Terry's 139 to 152. 3. Form of an original bill. 00 CCCCEEE 153 to 164. 4. Practical suggestions as to the drawing of bills. 165 to 173. Chapter 9. Proceedings preliminary to process. Article I. Proceedings preliminary to extraordinary process. 174 to 176. Idling so Tethys Bill E. 42 Excute Bani Ayat ES 177 to 179. 3. Proceedings in reference to costs. CCCCEEENS 180 to 183 Chapter X Original Process in Chancery. Article I Original Process Generally Considered. CCCCEEUEUEUUE 184 to 186 IL Subpoena to Answer. 0. CCEEUMLUE Ben 187 to 195 IL. Process by publication EEC San A and at Iras Vary 196 to 204. Attachment to compel an answer, E Salary 201 to 204 Chapter 11. Proceedings between process and appearance. Anmerkelli I pro CONFSOs, and proceedings thereon, ACIs 205 to 213 IL motions high the complainant. 0.0. CCCCCCENS 214 to 221. Proceedings in a suit in Chancery, from the appearance of the defendant to the close of the pleadings. Chapter 12. Appearance and Defense. Sections Article I. Appearance by the defendant, E0 EEE votes AEI 222 to 228 IL defenses generally considered. 002 SCCCE instances 229 to 232 3. Preliminary motions by the defendant, -2 EEE 233 to 239 Chapter 13. Pleas in abatement. Article I Pleas in abatement generally considered, 005 240 to 243 2. Pleas in abatement to the process. CCCEEC Senate 244 to 246 3. Pleas in abatement to the bill. 0. CCCCCEEs 247 to 252 4. Frame and form of pleas in abatement, 0.0000E 253 to 254 V pleas in abatement in attachment suits, 0.000000 255 to 259 6. Proceedings upon a plea in abate rent, 0.0000 EAE 260 to 265 Chapter 14. Motions to dismiss bills. 266 to 274 Chapter 15. Demurrers. Article I Demurrers generally considered. 000 CEE Petier 275 to 280 IL Demurrers by allowance, 0. 2 CCCE 281 to 288 IIE-demurred soft rights OLEIVEE ECAE 289 to 304. Rules governing demurrers. 0.0. CCCE CEEs 301 to 308b. Frame and form of demurrers. 00 CCCE is 309 to 312 6. Action of the Court on Demurrers, 00. CCEECEE 313 to 316 7. Practical Suggestions Concerning Demurrers, 6. 317 to 319 Chapter 16. Pleas in bar. Article I, Pleas in bar generally considered. 00 CCCCEEs 320 to 324 TEO ruins 26 FS pleas in, bar Bene RIIEOEEE 325 to 334 3. Frame and form of pleas in bar. CCCCCCEEE 335 to 344. Pleas supported by an answer 0.0.0.0. CCCCCCNERIRO 341 to 349b. Proceedings upon a plea in bar. RIPDEEE 350 to 354. 12.2. JII. 4v6. Article IIL. Article ITI. 3 Article ITI. IIT. 4 Contents. Chapter 17. Answers and disclaimers to bills. The answer as a pleading. CCCE ready the answer as a deposition. So CCCPEEEEs matters common to all answers. SCESSER is the frame and form of an answer. EEECEEC's practical suggestions as to answers. CEEEEEE. Disclaimers taught bills 420 pies ETT. OEOESOC her Aries Chapter 18. Cross bills. Chapter 19. The joinder of different defenses to a bill. Chapter XX. Analysis and comparison of pleadings. Rationale of pleaded $ts vaspir sre year in different defenses distinguished. CC scenes Chapter XXI. How pleadings are tested. Testing the sufficiency of pleadings. 0.ECEEE instances exceptions to answers 1.0.0. CCEE and CNEE suggestions as to testing pleadings. 00 CEE Chapter XXII. Amended and supplemental pleadings. Amendments to pleadings generally considered. Amended and supplemental bills. 0.00.0 CCEEAES amended demurs and pleas. CCCCCCEECSA Part 4. Sections 355 to 360, 361, 367, 368 to 376, 377 to 386, 387 to 392, 393 to 398, 399 to 401, 402 to 405, 406 to 410, 411 to 415, 416 to 419, 420 to 424, 425 to 426, 427 to 429, 430 to 431, 432 to 433, 434 to 437 proceedings in a suit in Chancery, from the close of the pleadings to the conclusion of the hearing. Chapter XXIII. Hearing a cause on bill and answer. Evidence in Chancery. Sections Article I evidence generally considered. 00 SEC Instances S 441 to 451 IL when proof is, and is not, necessary. Lee SEEs 452 to 457 3. Pleadings when evidence. Says 458 to 462 4. When proof must be filed. CC 463 to 468b Practical suggestions concerning proof. 0 EEEEE 469 to 473 Chapter XXV. Depositions in Chancery. Article DI. Depositions generally considered. 0. CCCCE Instances 474 to 479 IL Notice to take depositions. i.e. 480 to 482 3. Depositions taken on interrogatories. 20 EEEUEE 483 to 485 4. Formalities of a deposition. 0 CCCCCC NNN 486 to 491 B Powers and duties of commissioners, and rights and duties of witnesses data TK Acts. Merit Cs 10 Guhadema Swyrana EE 492 to 496 6. Exceptions to depositions. CISA 497 to 501 Bill Amendment of Depositions. 0.0. CCECNNN 502 to 504 8. Practical suggestions about depositions. E0 CQs 505 to 513 Chapter XXVI. Motions previous to the hearing. Article DI motions before the case is called. 0 CCCEC 514 to 518 IL motion for a continuance. 0 CCCCC SARE 519 to 522 3. Motions to dismiss the bill. Eddie on Dean REA 523 to 5.
all of these different evidences in Chancery. The next is going over, it just went over everything with the disposition and the considerations, dispositions taken on interrogatory behavior, so on and so forth. That is definitely very important when it comes to the law. But we're going to get to this real quick. I want you guys to hear more about equity in particular, so let's get into that real quick. Before we get out of here, I'm going to make this as quick as possible.
The scope of this work is sufficiently indicated by its title.
Equity.
Upon the voluminous subjects of equity procedure and equity jurisprudence, it does not profess to be an exhaustive treatise. It does not offer to compete with any existing work. It may be called a horn book, nothing more. It has not been prepared by contract. It is the gradual outgrowth of many years' experience and reflection in the work of practical instruction. There are two ways of teaching equity. One is to take up in succession, with more or less of technical detail, the practical topics treated in some approved textbook, until the time limited for that department expires. The other method is more elementary. It assumes that what the young lawyer especially wants is the faculty and the habit of original investigation. Give him that, and he will have no trouble in finding what he wants in the books, as occasion requires. It therefore aims to put the student in complete possession of those few central principles which command the whole field. Thorough mastery of those principles is given by historical explanation, by copious illustration, and by systematic drill. MM6 Preface. Some of these principles are so comprehensive and fruitful, that one who has grasped them in their fullness of conception has already mastered the system of equity.
Uh-oh.
All else is the application of these grand truths to particular circumstances. Pomeroy. The more elementary method is the one reflected in these pages. For the illustration of principle, the main reliance is, of course, upon adjudged cases. The student should be frequently called on to state from memory their substance in connection with propositions illustrated. This exercise
You
in the
guys know
present.
what equity is? I know there aren't too many of you even in the chat, but do any of you guys know what equity is? What do you invest your equity in, where you can go and presume your equity and ask for the interest on your equity? Have any idea? Anybody? You guys know? Where can you get equity from? There are multiple places and things that you've interacted on. Let's go. Think about it. Let's go.
Of a class gives accuracy of thought, clearness of statement, self-confidence. It is a discipline to prepare the candidate for his profession, not simply for his examination. In order to apprehend with ease decided cases, the learner must first be made familiar with the mold or form in which they are cast. For that reason, and also because the distinction between law and equity grows mainly out of the essential difference of procedure, that subject is first presented in brief outline,
That's right.
preceded by a chapter on courts.
Everything
The
you
effort
do
here
is
has been
equity.
to avoid as much of technical detail as is not inextricably involved with a fair outline of procedure. Passing thence to the complex subject of equity jurisprudence,
You already
its
know.
master principles are reached by two stages. The more fundamental ones, those upon the ground floor, so to speak, are grouped into a definition, and afterwards maxims are considered with their illustrations. The definition is simply a piece of temporary scaffolding to aid the student while he is building up a fuller conception for himself, after which he will have no further use for it, except to refresh his memory and seek coordinate his results. It is short enough to be remembered, and comprehensive enough to furnish the analytical basis for a sufficiently full discussion. The maxims of equity are so classified and arranged as to present the form and substance of a connected system. Their contrasted functions are exhibited in two opposite tables, under the respective heads of enabling and restrictive maxims. This is merely another device to aid the understanding and memory. With these general principles and their practical illustrations, the course closes. If proper use is made of the cases cited, or even of a moderate selection, there will be no time for more. As these citations are drawn from the whole field of juridical equity, the student will have incidentally learned much of its practical doctrines. Imperfect as the execution of the plan may be, the plan itself, that is to say, the elementary method of instruction, has received the weighty approval of the American Bar Association. In the report of the Committee on Legal Education, submitted at the Saratoga meeting in 1892, the professedly technical method of instruction is condemned upon the ground that Edville Preface. The entire
When we think
time,
about instructions, what is instructions? When you're demanding equity, you have to do what? You have to send in an affidavit of your truth. What is equitable? You have to define that. You have to make sure that you're defining the equitability and the principle of interest that have been occurred on whatever the item is, or your incident, or your damage, or the invasion of your property, your intellectual property, your biological property, all of these things, right? So when put them in the correct form or the scope of manner, you have to understand these things so that you're able to astutely present what you are deserving and why. What has been taken from you? What are you demanding back? What is due to you?
spent in the study of the law is too brief and precious to be wasted in merely committing to memory what the learner can find in the books as he wants it. On the other hand, they recommend that process by which the student's memory is charged only with those fundamental principles which he must always carry there in order to make any use of them, and by which he is given a complete and thorough comprehension of the nature of the subject, under which all his subsequent acquisitions will arrange themselves according to the very law of thought. The substance of the same idea was concisely stated in a recent address to English law students by Sir Edward Fry. Revelation for April, 1898. An American jurist of international reputation, in his latest publication, issued from the press since the following pages were printed, has placed his unqualified endorsement upon the report above cited, which seems also to have made a powerful impression upon the Council of Legal Education of the Inns of Court, Dillon on the Laws and Jurisprudence of England and America, 82. Himself a former professor of equity jurisprudence in the Law School of Columbia College, Judge Dillon further criticizes the course of instruction in our law schools as too intensely practical and technical, and suggests that the great drawback today, alike of the teacher and the student, is the non-existence of elementary works written by lawyers of competent learning and experience, designed for the specific purpose of enabling the teacher to teach and the student to learn the elements, the great primordial and essential principles of our jurisprudence. 7 bid. 86, 87. This textbook is easily perceived to be designed primarily for the Maryland law student. In the absence of any other book on a similar plan, it may be found helpful to instructors and students elsewhere. It will be seen that there are liberal citations of recent federal and state decisions, as well as from the latest English reports. The references, generally, are of a character to be serviceable to the equity practitioner, to whom it may also be suggested that among old things for young heads there may perhaps be found some new things for old heads. For valuable assistance in the compilation of the table of cases, acknowledgement is due to C. Hopewell Warner, Esq., and in the preparation of the index to the same gentleman, in connection with Ralph Robinson, Esq., both members of the Baltimore Bar, and Maryland University graduates of 1893. For whatever notice he may receive of errors discovered, whether of omission or commission, the writer will be grateful, and he will also be grateful to the mind which coined the consoling reflection, that the man who never makes a mistake, never makes anything. C. E. P. Marcu, 1894. Part 1 Courts, Procedure. Chapter.
Let's go on.
Section.
Fast forward.
I courts or
Course of
equire.
equity.
RR. 1 to 19.2. Equity procedure. Parties. 20 to 48.3. Pleading and evidence. N. 49 to 71.4. The decree and its incidents. 72 to 85 v6. Practice. 86 to 112, 118 to 198. Part 2 Equity Jurisprudence. 7 Re-jurisprudence, IRS Genesis and Evolution, Definition, 199 to 148. 8. IRS Nature and Extent, the definition expanded. 144 to 156. 9. The definition of the expanded. 1-5. Courts of Equity. 1 Curia Regis. 2 Courts of Westminster Hall. 3 High Court of Chancery its ordinary jurisdiction. 4 Writ. 5 Chancellor his extraordinary jurisdiction. 6 Ecclesiastical Courts. 7 Their specific operation. 8 Their influence upon Chancery. 9 A hybrid product. 10 The war between the courts. 11 Other courts of equity. 12 House of Lords. 13 Organization of the Court of Chancery. 14 to 15 Its abuses, reform and abolition. 16 Judicature Acts. 17 Courts of Equity in the United States. 18 Federal Courts. 19 Courts of Equity in Maryland. 1. Curia Regis. All courts of equity, as to their jurisdiction, principles, and procedure, are substantially modeled after the late High Court of Chancery in England.
Modeled after Chancery.
To find the place in history of this venerable court, it will be necessary to go back to the Curia or Alla Regis of the early Norman kings, and trace the successive formation of the historic tribunals which eventually came to supersede it. While 11 BL. Commander 147, 3 BL Commander 46 to 55, 426 to 455, 1 Spence, EQ 78, 4, Hallow. Making this inquiry, it is to be remembered that the strict separation of the 3 great branches of government between the executive, legislative and judicial departments, which has been found so essential to constitutional liberty, is an idea of modern growth. All these attributes of sovereignty were in very early times confounded and concentrated in the crown. The agora of primitive Greece was the scene in which justice was administered, and the king is spoken of as constituted by Zeus, the great judge of society. Amnes, on his arrival in Carthage, finds the queen engaged as legislator and judge. The judges of Israel were de facto rulers. The judgments of Solomon were highly esteemed. The crown. The agora of primitive Greece was the scene in which justice was administered, and the king is spoken of as constituted by Zeus, the great judge of society. Amnes, on his arrival in Carthage, finds the queen engaged as legislator and judge. The judges of Israel were de facto rulers.
The judges of Israel were de facto
Solomon were
rulers.
highly esteemed, although hardly available as precedents. In like manner, the kings of Old England claimed and exercised both judicial and legislative power.
I hope y'all hear it.
In the first act of and the judgments of Solomon were highly esteemed, although hardly available as precedents. In like manner, the kings of Old England claimed and exercised both judicial and legislative power. Shakespeare, in the first act of King John, dramatizes a suit involving the title to real estate, heard and decided by the king in person. 1 Dorsey, 37 MD J. Law. Coomer's case, Curia Regis. 3 This was not, however, a despotism of the Oriental type, as, with the standing army, it might have been. It was a despotism tempered by the feudal system, and by an alien hierarchy. The king was only primus inter pares. It was his policy to conciliate his peers, temporal and spiritual, who, united by a common grievance, could at any time have arrayed against him the physical force of the realm, and aroused the thunders of the Vatican. Practically, barons and bishops were recognized as an advisory council in all matters of administration. This great council, which at the Norman conquest took the place of the Saxon Wittenagemot, was the germ of the parliament.
The germ
it does
of
not
the
fall
parliament.
within present limits to show when or how council in all matters. The king was only primus inter pares.
Y'all ain't hearing it.
Was his policy to conciliate his peers, temporal and spiritual, who, united by a common grievance, could at any time have arrayed against him the physical force of the realm, and aroused the thunders of the Vatican. Practically, barons and bishops were recognized as an advisory council in all matters of administration. This great council, which at the Norman conquest took the place of the Saxon Wittenagemot, was the germ of the parliament.
The germ of
It
the
does not fall
parliament.
within present limits to show when or how the commons were called in by representation as a financial expedient, nor how the great council divided
Oh,
into two
equity.
houses of
Financial
legislation.
expedient, huh?
Attention is rather to be given to a lesser council, formed out of the great council, of a select number of peers, including the chancellor and other dignitaries of the palace. This was the Curia Regis, par excellence, the same term being sometimes applied to the Great Council, the germ of the Privy Council,
The
and
germ
of
of
the
the
higher
council,
courts of
privy.
justice. The limits of its jurisdiction were not accurately defined, being mainly appellate, but sometimes original, exercising apparently the broad powers of a board of arbitration. It has been called a Supreme Court of Judicature administering equal justice, a court to law or equity, as the case required. But its functions were not wholly judicial. $9. Courts of Westminster Hall. The first court of original jurisdiction which grew out of the Curia Regis appears in its infancy to have been simply a board or committee of barons to audit matters of revenue. By the aid of fictitious allegations, these barons of the exchequer came at length to constitute a court of general jurisdiction, both at law and in equity, called the Court of Exchequer. These were the days of sparse population, bad roads, travel on horseback, and sumpter mules. It was easier for the king and his retinue to pack up and travel to find their supplies, than for supplies to be hauled. After exhausting one region of country, they merrily saddled up and rode off to fresh fields and pastures new. Hence we read of old statutes passed at different places, and hence justice, like legislation, was ambulatory. After a while suitors tired of chasing justice on horseback, and the clamor for a stationary tribunal became loud enough to be heard in Magna Carta, which provided that common pleas, suits between subjects, should be held 13 BL.
We just went through that, right? Well, not us, but the so-called government just went through the tribunals, right? This is something that we are actually benefiting from behind the scenes. You have to just get your shit in order, like literally. I don't know why this stopped. I didn't even talk that long, but let's go. On to the next page. Oh, goodness. Okay, let's go.
To law or equity, as the case required. But its functions were not wholly judicial. $9. Courts of Westminster Hall. The first court of original jurisdiction which grew out of the Curia Regis appears in its infancy to have been simply a board or committee of barons to audit matters of revenue. By the aid of fictitious allegations, these barons of the exchequer came at length to constitute a court of general jurisdiction, both at law and in equity, called the Court of Exchequer. These were the days of sparse population, bad roads, travel on horseback, and sumpter mules. It was easier for the king and his retinue to pack up and travel to find their supplies, than for supplies to be hauled. After exhausting one region of country, they merrily saddled up and rode off to fresh fields and pastures new. Hence we read of old statutes passed at different places, and hence justice, like legislation, was ambulatory. After a while suitors tired of chasing justice on horseback, and the clamor for a stationary tribunal became loud enough to be heard in Magna Carta, which provided that common pleas, suits between subjects, should be held 13 BL. Commander 3749. Our associations of courts of justice will mislead if applied to the courts of the early kings. They were more like public meetings for the transaction of public business generally, whether judicial, financial or military. One step.
Dang it.
History CR Law, 77. 2 Cohort Court. $AD, 1215. In some certain place, afterwards established at Westminster. Hence the origin of the Court of Common Pleas. the second court of original jurisdiction which grew out of the Curia Regis. Finally, the Curia Regis itself, or what was left of it, the king in person being supposed to be actually present, assumed, or rather, retained, the name of the Court of King's Bench. The times when the king undertook to dispense justice himself were naturally crude. Commerce was rudimentary, contracts few. Tedious disputes about land he was glad to delegate to his judges of the common pleas, perplexing revenue matters to his barons of the exchequer. Like a father settling disputes in his family, or a patriarch in his tribe, the king as judge would naturally find his attention most attracted to simple cases involving a breach of the peace. Hence we find the primary jurisdiction of the Court of King's Bench limited to criminal cases and to such civil causes as savored of a criminal nature. In the general scramble among the courts for civil business, as cases multiplied, the King's Bench managed to get its share, and enlarged its jurisdiction by means similar to those used by the Court of Exchequer, so as to include civil common law causes generally. The justices of this court, besides their duties in bank, also rode the circuit of the counties, presiding over the trial of issues at nisi prius. And thus the functions of the old county courts, presided over by one assizes. The sheriff, which had come down from Saxon times, were gradually
The
absorbed,
sheriff,
and those
the
courts
only
finally
true law of the
superseded.
land,
There was
not
also an
police
intermediate appellate
officers,
court called the
policy
Court of Exchequer
enforcers.
Chamber, consisting, in certain cases, of all the judges, and, in certain other cases, of a majority of them. As this was a tribunal of later and statutory origin, nothing more need be said of it here, except to note its coordinating influence in securing some degree of uniformity in legal procedure. 3. High Court of Chancery.
We'll get back to the High Court of Chancery. I want you to get an idea of Chancery before we get out of here. I want you to get a little bit of an idea of the scope of Chancery Court. I'm going to get here. I want you to just hear in the decreeing of the account of the court, just to get an idea. So let's go. Hold on 1 second. We about to be out of here.
Or the distribution of the proceeds of a decree. Reduce the matter, confusion, disappointment, and delay. 7. Endearing an account. The court should settle and specify the principles on which the account is to be taken, and, when practicable, should define the powers and duties of the master, and indicate, in a general way, what he is required to do in each particular matter referred to him. 18. The object of such rulings and directions is to narrow the range of inquiry, to point out to the master the paths for him to pursue in his investigations, and thereby prevent the unnecessary accumulation of costs. The court should, also, rule on disputed matters of evidence, and specify what books of account, or other evidences of account, what settlements, and what other proofs, the master may consider, and what weight he should give them, and what rights of surcharge and falsification, or what other liberties the various parties may exercise.
What does it sound like to you guys, right? The court should what? Rule on disputed matters of evidence. What would the evidence be? And specify what books of account, books of account. That would be anything dealing with financial, right? Or other evidences of account. What settlements are funding that are issued when those are wronged or taken advantage of, or their property stolen, so on and so forth. And what other proofs the master may consider, and what weight he should give them, what he would consider it, if this proved valid, so on and so forth. What rights of surcharge and falsification, what other liberties and various parties may exercise. What liberties can they take to exercise their rights in order to take the equity from something that has been, they have been abused from, right? Let's go. Here this crap go.
Or the distribution of... The court should, if the chancellor, at the hearing, has reached a definite conclusion as to any large items of the account, the court should, also, rule on disputed matters of evidence, and specify what books of account, or other evidences of account, what settlements, and what other proofs, the master may consider, and what weight he should give them, and what rights of surcharge and falsification, or what other liberties the various parties may exercise. If the chancellor, at the hearing, has reached a definite conclusion as to any large items of
A
the account,
definite
he should
conclusion.
so find, and direct the master to take such items as prima facie, or absolutely correct, or to totally reject them, as the case may be. 9. If there be agreements to be construed, or instruments to be passed
Or
on,
instruments.
the decree of reference should settle the construction and effect of such agreements, and determine the validity and meaning of such instruments, so that the master may be neither entangled nor embarrassed by such questions. References, however, may be made by consent, without any preliminary determination of prineiples. 600. The frame of a reference. If the order of reference is to elucidate some matter in controversy, it must necessarily inform to the issues raised by the pleadings. If the reference is not for the purpose of aiding in the determination of the matters in controversy, it must, nevertheless, relate to some matter pertinent to the pleadings, or to the decrees, or to the subject.
So you don't want to go into court if you're coming about a matter of securities. Hey, my securities were stolen. They were abused this way because of a faulty contract. I'm now seeking restitution in the form of equity and interest on the principals that are owed to me. When you're writing out your information, you don't want to put in there, oh, they get on my nerves, they did this and they abused my rights and blah blah blah. You're going to stick to the facts, right? The point of the matter is, what were the things they did on this day? In fact, this person such and such did blah blah blah, and they blah blah blah, they did this and that. I did on this day commit this thing by saying this, or submitting papers, or requesting them to refund what they have taken, whatever it is that's happened in your particular case, right? Damn, this thing annoying.
Or the the decree of reference should the frame of a reference. If the order of reference is to elucidate some matter in controversy, it must necessarily inform to the issues raised by the pleadings. If the reference is not for the purpose of aiding in the determination of the matters in controversy, it must, nevertheless, relate to some matter pertinent to the pleadings, or to the decrees, or to the subject matter, or to the funds or property in the custody of the court. The order of reference should clearly indicate the matter to be reported on, and if any rules or directions are necessary for the guidance of the master, they should be specified. The order should not only contain all the specified directions necessary to enable the master to understand what he is expected to do, but should lay down with particularity the principles on which he is to act, to the end that the inquiry may be made as narrow as possible. N.A.
So you don't want to go in there and say, hey, I think that they should do this or that. I feel like they need to do this or that. They did me wrong, so I would like, or I'm asking, you're demanding, because you're what? The master. You are the master. And it says the guidance of the master, right? The order of reference should clearly indicate the matter to be reported on. You are the person reporting, right? And if any rules or directions are necessary for the guidance of the master, they should be specified. So you will say, you don't want to say, I think, I want, I should, I could, would you, I'm asking. No, you want to say, I'm demanding to be paid in full in the amount of such and such and such, recovering all equity and principles that are owed to me in the amount of such and such amount. Such and such company on this day committed fraud, and they abused their fiduciary responsibilities and impeding upon my trust and not following upon the things that they should do. Boom, you're going to let them know what's going on from there, and you're going to lay out all the rules and tell them what you're seeking in the form of equity. What do they owe you? What is your loss? Detailing these things.
L. Impertinent and unnecessary matters may be excluded. Point 22. If any book of account, or settlement between the parties is deemed prima facie correct by the court, the order of reference should so state, and leave be given the attacking party to surcharge and falsify such book of account, or settlement. 23. But if stick settlement is wholly set aside, and an account de novo ordered, the decree should so state. References to the master. 17. Carey v. Williams, 1 Lee, 51, Patton v. Cone, 1 211 Dan. CHPR, 857, Note, 2 Ibid, 992, Wesley, 14, Terrell v. Ingersoll, 10 Lee, 77 Sells v. Wessels, 1 Tennessee ch. 58, Trimble v. Dodd, 182 Dan. CHPR, Dan. 2 Dan. In ease of a referee for an account, DR for a reference as to more matters than one, the order should be divided into parts, each part.
Each part we will discuss at a later date, guys. I'm about to get out of here. Peace, love, and bliss to everyone. Enjoy your day. I will be coming back with more on equity. I know I went over Chancery court a little bit, but not the equity. So we're definitely going to cover that a little bit more. I want you guys to understand this and how important it is. I hear a lot of people are like pushing the UCC. No. There are other ways of you making sure that you're getting your equity and taking control of your subsidies, in different ways so that these people aren't abusing you in your rights, right? Using the form of Chancery for Equity Court will put you in tune with exactly what you need to do. Okay? That's what we're going to be doing. So, peace, love, and bliss to everyone that came in, even the ones that didn't speak, that was just listening with a quiet ear. I know that you are looking to enlighten yourself, even if you don't want to, speak or have anything to say. You need to get out of these portals of information that keep people from blocking each other instead of supporting each other. It's real sick. Peace, love, and bliss. I am out, guys.